In any discussion of the New York Convention, one probably ought to start with the title. Convention on the Recognition and Enforcement of Foreign Arbitral Awards is actually quite misleading. And so there is immediately a problem with the Convention. And the problem relates to Article 1, which is where we're going to start our discussion. Article 1 explains that the Convention applies to the recognition and enforcement of arbitral awards made in the territory of a state other than that in which recognition is sought, etc. But it doesn't actually talk about the agreements that will be enforced under Article 2. So the scope of application provision of Article 1 essentially doesn't work for Article 2. It's quite difficult for Article 1, although if you understand where it's coming from, Article 1 starts to make some sense. Article 1 contains in it the traditional conflict which has long disappeared between countries that saw arbitration in terms of the seat of arbitration, where the arbitration occurred, where the award was rendered, being the country which governed the whole process, and those which took a more conflict of laws type approach, which looked in terms of what the parties agreed to by way of a procedure. That country was to determine how everything worked in the arbitration. This conflict has disappeared, partly because of the Unstral Model Law, but also many other developments since 1958. The net result is that in most countries, most of the time, the only thing we really need to worry about with Article 1.1 is to discover whether the award was actually rendered in a country other than the place in which the award is sought to be enforced. There is one very well-known exception in the USA. It's called the Bergeson and Joseph Muller case. And it hinges on the last sentence of Article 1.1, which says it shall also apply to arbitral awards not considered as domestic awards. Now, in that particular case, there were two parties which had nothing to do with the USA agreeing to arbitrate in the US. In truth, the case really hinges on the way in which the US adopted the New York Convention, and frankly it's their privilege if they wish to expand its application beyond the scope of Article 1. So in a weird sort of way, the Bergeson case is quite misleading for people who actually want to understand how the Convention works. Apart from that, you obviously have the problem of deciding what an arbitral award is. In 1958, the big question of the day probably concerned two things. One, Arbitrato Irrituale, a strange Italian institution basically created to prevent the parties from having to confirm their arbitration award in the local courts if they wanted to get the award enforced. This is a bit of a throwback, if you think about it, to the Geneva Convention and the double exequatur, an idea which was enthusiastically, perhaps one could say over-enthusiastically, adopted by the Italian courts. The other possibility, which is the subject of Article 1.2, were the state bodies created by the socialist, now former socialist countries of Eastern Europe. Were they arbitration awards? Well, Article 1.2 says very clearly that they were, that they could be arbitration awards rendered by permanent arbitral bodies to which the parties have submitted. So you still had to agree to arbitrate under the rules of Romanian or Bulgarian institutions in order for there to be an award. But if you did, that's what came out the other side. This was primarily to tie in the countries of Eastern Europe into the New York Convention. Now the question has become completely different. Totally different, actually. The sort of questions we're concerned with these days relate to things like... So I'm going to do that sentence again. Now, the question about what is an arbitration award tends to relate to different subject matters, like domain names. When you register a domain name, you agree to be bound by the registration agreement of the registrar, which makes you subject to a complaint potentially brought to any of ICANN's institutions. That is to say, if you've registered a .com name. There are different institutions if you register various country names instead. So is such a dispute, or is such a complaint, an arbitration? Has become quite a big issue. And nobody really knows is the actual answer. Other areas that could be in dispute might be sporting arbitration, but courts generally have agreed that this is indeed arbitration, even though there is an element of punishing athletes for breaking the rules. So in a sense, it's quite different from traditional arbitration. The last part of Article 1, paragraph 3, concerns the reservations. There are basically two of them. The one that can cause problems is the commercial reservation because, like the Geneva Protocol and Convention, Article 1.3 allows contracting states to limit the application of the Convention to subject matters which, under their own law, are considered to be commercial. The problem here is that with economies that are quite heavily run by central government, the distinction between commercial and public starts to fade a bit. And there is always a risk with totalitarian regimes of various types that the definition of commercial can become so small as to become insignificant. So far it hasn't caused a major problem, but it is one of those things one worries about. The second reservation is reciprocity. This has caused a few laughs rather than any major problems. The laugh I'm thinking of is the Indian fertilizer case in the USA, when it was unsuccessfully argued that the US reservation of reciprocity meant that the award could not be enforced because the place of arbitration, India, had so consistently misapplied the convention through its courts that it couldn't actually be considered to be a contracting state. Interesting argument, but one that will never work, because you have to define reciprocity arrangements in terms of whether you have ratified the agreement, not whether you've applied it correctly. Which gives rise to one last point about Article 1, that there is no mechanism in the Convention for making sure that people actually comply with it. So contracting states can make a terrible mess of adopting the Convention, can enact the wrong legislation, and their courts can make a consistent mess of applying it. And there is absolutely nothing anyone can do about it.